Hi. In this unit, we continue our discussion of assent. In this unit, we will focus on the common law mirror image rule. It's unit 2.5, subunit 2.5. I was a little slow. Sorry about that. All right, let's learn about the mirror image rule. But first, let's set up the context for the mirror image rule. Remember, we're talking about mutual assent, and we're talking about offer and acceptance. The mirror image rule deals with a situation where the offeree's acceptance has terms that are additional to or different from the terms of the offer. In other words, the acceptance is somehow different from the offer. The common law deals with this issue through the mirror image rule and its close cousin, the last shot rule. In Unit 3, we'll discuss the UCC approach to this problem, which is different from the common law approach. In Unit 3, we will discuss Section 2-207. All right, let's discuss what it means when we have an acceptance that has terms that are additional to or different from the terms of the offer. If a term in the acceptance is additional to the terms of the offer, that means the offer is silent on the issue. If we have a term in the acceptance that is different from the terms of the offer, that means the acceptance contradicts some sort of term that is in the offer. All right, let's look at an example of the mirror image rule in action. Imagine homeowner sends an offer to carpenter. Please build a jungle gym in my backyard, blah, blah, blah. I am willing to pay $2,000. Please let me know if you accept this offer. Carpenter responds by email. I accept, but it will cost you $3,000. Look at that. $3,000 is a different term from the offer. In the offer, homeowner was offering to pay $2,000. Carpenter's email response is not an acceptance, even though it uses the word accept. This brings us back to an earlier lesson we learned. A qualified acceptance is not an acceptance. So here we have a qualified acceptance on the part of the carpenter. I accept, but it will cost you $3,000. This is not an acceptance. At best, it is a rejection and a counteroffer. All right, let's look at another example. Contractor's email to plumbing subcontractor. We need you to do the plumbing work for the Gleason Theater project. The specifications are attached. The job will pay $100,000, start on January 15th, completion within 6 months. So contractor is looking for a subcontractor to do the plumbing work and makes an offer to our subcontractor. Subcontractor responds, we accept. We will start on January 15th and complete within 8 months. Any disputes under this contract shall be resolved in Ohio courts. The laws of the state of Ohio shall govern this contract. All right, so of course the question is subcontractor's response an acceptance? Look at 8 months. Look at the offer. The offer was seeking 6 months. The acceptance has a different term than the offer. Under the mirror image rule, this is not an acceptance. All right, but there's more for us to look at. Any disputes under this contract shall be resolved in Ohio courts. Look at the offer. Look at the original offer. Is there any mention of dispute resolution? Is there any mention of jurisdiction in contractor's email to plumbing subcontractor? No. So this is an additional term. An additional term in the acceptance is not an acceptance, and therefore subcontractor's email is not an acceptance because it contains this additional term. There's another additional term. The laws of the state of Ohio shall govern this contract. Do you see anything in the contractor's email to plumbing subcontractor that says anything about choice of law? That's what this clause is, a choice of law clause. There's nothing in the offer. So, subcontractor's choice of law clause in its acceptance means that its acceptance is not an acceptance. An acceptance that contains an additional term, a term additional to the terms of the offer, means that the acceptance will not operate as an acceptance. So at best, subcontractor's email response is merely a counteroffer to contractor. All right, let's look at the actual rule, the actual mirror image rule. The mirror image rule states, a purported acceptance that has terms that are different from or additional to the terms of the offer does not operate as an acceptance. It is a counteroffer. All right, and now a quick look at our hypothetical. We've established that subcontractor's email response, although it purports to be an acceptance by saying we accept, it has different terms, 8 months, which is different than the 6 months in the offer, and it has additional terms. There's the dispute resolution clause, and there's the choice of law clause. Because subcontractor's email has different terms, it will not operate as an acceptance. Or you could say, because subcontractor's email has additional terms, it will not operate as an acceptance. So this interaction between contractor and subcontractor does not constitute a contract. At best, subcontractor's email is a counteroffer. All right, so we've discussed the mirror image rule. Let's talk about the consequences of the mirror image rule. Let's talk about the last shot rule. So we know that the acceptance will not operate as an acceptance if it has terms that are different from or additional to the terms of the offer. It will operate as a counteroffer. That's the mirror image rule. Well, what if the parties aren't careful and they're not reading these documents very carefully, and they perform the contract anyway? What terms of the contract govern the transaction? Well, we have a contract based on conduct. So we do have a contract. We don't have a contract based on offer and acceptance, but we do have a contract based on conduct. Whose terms control? The terms of the offer or the terms of the acceptance? Well, the last shot rule says the terms of the acceptance control. What's the reasoning behind this? Well, the acceptance was a counteroffer. And then when the parties performed, the original offeror now became the offeree and accepted the counteroffer by performing. And so the last shot wins. In this case, the purported acceptance, which contained additional or different terms, wins the day because it was a counteroffer and the parties performed the contract. All right, let's once again look at contractor's offer to subcontractor and subcontractor's response. So now the question is, what are the terms of the contract between the parties, assuming they have performed? Remember, this offer and this acceptance is not a contract. Why? Because the acceptance does not operate as an acceptance. But if the parties perform, now we have a contract based on conduct. We said subcontractor's email was not an acceptance, but it is a counteroffer. So when the parties perform the contract, the terms of subcontractor's email will govern the transaction. And therefore, subcontractor will have 8 months to complete the work. And if the parties have any disputes under the contract, they have to go to Ohio courts. And if they have any disputes under the contract, the laws of the state of Ohio will govern the transaction.